This is case number 21 CR 186, 21 CR 202, both State of Ohio versus Ralph S. Morse. This hearing is being conducted by Zoom remotely. The state is represented by the Assistant Prosecuting Attorney King. Defendants represented by Attorney Jacob Wagner, both of them are appearing from their offices. And you are Ralph S. Morrison appearing from the jail.
Sir, I'd like to postpone this to speak to my lawyer, sir, but yes, I am.
Okay.
I would like to have a continuous, so to speak. I'm not ready to make anything like that, sir. I would like to speak to Mr. Wagner if I could, sir.
Well, I can go ahead and put you and him into a breakout room so you can talk now. That'll be all right.
I'm going to need a little bit more time than that, sir.
So you would like him to talk to you at the jail?
Yes, sir.
All right. Okay.
Judge, if I may, sir?
Yeah.
I'm not sure if the court's docket, Your Honor. I'm free the rest of the day. I can run out and report back to Marcia.
Yeah, I mean, I'm good until 3:30 somewhere. I can try to get out by 3:30, so if you can get out there. And if not, I think tomorrow I have time. I have a pretty light schedule. Friday morning, I'm available up to about 9:45. Then I'm going to be participating in a board of conduct hearing the rest of the day. So, yeah, we can do it later this afternoon if the two of you come to some sort of a understanding, and if not, Friday, or we can just leave. So I'll go ahead and just continue this hearing, and Mr. White will be out to see you, Mr. Morrison. Okay. All right.
Your Honor, thank you very much, sir.
You're welcome. No problem. Okay. I'm going to go ahead and leave this on because we have other hearings coming up, so you can go ahead and log out, Mr. Wagner.
I'll just call back, Judge.
All right. And I think the jail can log out too, because the next
Recording in progress.
All right, are you Rebecca Captain appearing on the screen is marked Rebecca Smith? Can everybody hear me?
You must be muted.
No, they cannot hear me. Oh, that's because I'm muted.
Yeah.
Okay. All right, are you Rebecca Captain appearing on the screen marked Rebecca Smith?
What is it?
Are you Rebecca Captain?
Yes.
All right. Well, let record reflect Miss Captain's appearing on the screen. It is identified for purposes of this hearing as Rebecca Smith. This is case number 21 CR 192, State of Ohio versus Rebecca L. Captain. Appearing on behalf of the defendant is Attorney Dennis Kirk, and appearing on behalf of the state is Assistant Prosecutor Attorney King. This hearing is being conducted by Zoom, remotely rather than in person, and Mr. Kirk, you and your client both stipulating to having this hearing conducted remotely by Zoom rather than in person.
Yes, Your Honor.
All right, you're in agreement with that, Ms. Captain?
Yes.
Okay. Now, Ms. Captain, since you are not in the courtroom with your attorney, if during the period or during this proceeding you would like to speak with him, to have him explain something or to ask him a question, just tell me and I can put you and him into a breakout room where it'll be just the two of you on the screen talking alone and nobody else will be able to see or hear you, okay?
Okay.
All right, the record reflects that Ms. Hampton has been indicted with, in one count with charge of tampering with evidence, a third-degree felony, and I know this matter is set for trial. I knew it earlier, but I think it's the next month sometime.
March 7th.
March 7th. Okay, it was a ways down the road. Okay, March the 7th. Thank you. The matter was set today for a plea after the court staff was informed that the parties had reached agreement. And Ms. Captain, I've been presented with a plea of guilty form, which says that you're going to withdraw your not guilty plea to the indictment and plead guilty. I'm going to hold this up to the camera so to confirm that this is the agreement that you saw earlier when you signed it. You recognize that form?
Yes.
All right. It's a 3-page form prepared by the prosecutor's office, and on page 3, there is a sentence about a third of the way down that reads, "I enter this plea voluntarily." And immediately below that, there's a line with signature defendant printed below it, and I'm looking at what appears to be Rebecca L. Captain as a signature. So I'll hold that up to the camera and ask you if you recognize that as your signature.
Yes.
When did you sign this document, Ms. Captain?
Right after court, we did last
Okay. And did your attorney go over it with you and explain it to you before you signed it?
Yes.
Yeah, okay. And did he answer any questions you had and explain everything to you to your satisfaction? And do you feel that you had enough time to fully consider this matter before you signed this document?
Yes.
And is it still your decision to go forward with this plea agreement since it's been a few days since you signed it?
Yes.
You're entering into this agreement to plead guilty voluntarily?
Yes.
Right. Now, the agreement states on page 1 that you're going to withdraw your not guilty plea, plead guilty to the charge of tampering with evidence, a third-degree felony under section 2921.12A1 of the Ohio Revised Code. It further states that you understand that the maximum penalty for this, if convicted, could be 36 months imprisonment. If it's a prison term, it would be a minimum of 9, and there are certain levels in between those two ranges prescribed by statute. And there's a possible fine of up to $10,000. You understand that?
Yes.
Are you facing any felony charges in any other jurisdiction?
No, Your Honor.
Are you currently on probation, community control, parole, or post-release control for a felony?
No.
Right. Now, under the law, if a person is convicted of this offense and sentenced to prison, upon completing that prison term, the law provides that the adult parole authority has the option to put a person under what's called post-release control supervision for a period of up to 2 years. So they don't have to, but they can. But the parole authority makes that decision, not the judge. If they decide to do that, you'll be supervised under the terms that they set by a parole officer, and if during that period of time they determine that you've not complied, then they could return you to prison even though you served the entire term that was imposed by the court for an additional period of up to 9 months for any one violation, but there is a cap or limit of half of whatever prison term was imposed for all violations. But if you are convicted of a new felony while under post-release control supervision in this case, then in addition to whatever sentence the judge in the new case would impose, that judge could also sentence you to an additional period for committing that offense while under post-release control in this case, to 1 year or whatever time was left on the post-release control, whichever is greater. If that occurred, that would have to be served consecutively to the sentence in the new case. You understand that?
Yes.
Now, under the law, I'm not required to sentence you to prison for this offense. I can impose what's called community control or non-prison sanctions, and that's basically the term that we refer to as, that most people refer to as probation. That would mean you would be supervised by a probation officer under the terms set by the court, and the maximum period of that could be 5 years. Now, if during that period of time you were being supervised, the probation department felt you were not complying with the conditions, they would have to file a written allegation of that with the court, show a copy on you. You would then be entitled to have a hearing, and you would be entitled to be represented by an attorney. If the outcome of that hearing was that you had failed to comply, then at that time the court could revoke your community control and then sentence you to a period of 36 months and fine you $10,000. Do you understand that?
Yes.
All right, now, Ms. Hampton, the charge in this case alleges that on or about the period of September 15, 2021, continuing through October 19, 2021, in Hainan County, Ohio, that knowing that an official proceeding or investigation was in progress or was about to be or likely to be instituted, you did alter or destroy, conceal, or remove a record or document or thing with the purpose to impair its value or availability as evidence in such proceeding or investigation, in violation of Section 21.12A2 of the Ohio Revised Code. So that's the charge, the third-degree felony. Now, you understand what it is you've been charged with in that indictment, what the state said you did, when, where, how they alleged that you did.
Yes.
And have you discussed the nature of the charge, the evidence in the case, possible legal issues you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes.
Are you satisfied with his advice and confidence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Has anyone threatened you to, well, let me back up. Are you taking any prescription drugs of any sort?
I have quite a few prescriptions. I have a lot of health issues.
All right. Do any of those prescriptions interfere with your ability to understand, comprehend, read, and understand, or just express your thoughts?
No.
Okay. Now, has anyone threatened you to make you plead guilty here today?
No.
On page 2 of the agreement, there's a line, slightly more than a line, that is printed in bold and reads as follows. Defendant shall enter plea guilty to the indictment, state defense argued sentence. Is that your understanding of the agreement?
Yes.
Has anyone promised you anything other than that to get you to plead guilty here today?
No.
All right, now do you hold any license or certification from any state governmental agency for any kind of profession or occupation?
No.
All right, do you have certain constitutional rights, you must understand, before I can accept the plea of guilty from you? First of all, you do have a right to have counsel. I believe you employ Mr. Kirk to represent you. Now, in the event that you were not able to continue to pay him to represent you in this matter, the court then would appoint an attorney for you at no cost to you, but to pay for that. And so the reason I say this is just to make sure that, in my mind, that you're not entering into this agreement, plead guilty, because you're worried that you're not going to have enough money to pay your attorney.
Oh, okay, no,
Okay, so you're, that doesn't have anything to do with your decision.
correct.
All right, thank you. Went to the jail to log into.
Okay.
All right, now, you have a right to have a jury trial in this matter, Ms. Captain, in which 12 people who would be chosen to be your jury from a group of citizens who live in this county that are summoned for jury duty on your trial date. And so, after those 12 folks are selected, the evidence will be presented, they've been instructed on the law by the judge, and then that group of 12 members of the jury would have to decide by an unanimous verdict, meaning that all 12 of them would have to agree as to whether or not the state proved you're guilty. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, and in the legal sense, waive means to give up the right to have a jury trial on this charge, and in that case, you would have to hold a court or bench trial. What that is the judge is the one who hears the evidence instead of the jury, and then the judge will apply the law, and then the judge will decide whether or not the state proved you're guilty of the charge. You understand that?
Yes,
All right, now, Ms. Captain, under the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them for your attorney. What that means is that the witnesses against you have to come into the courtroom and testify in front of you and your attorney and anyone else that may be present. After the prosecutor's done asking questions, your attorney would ask questions. That's called cross-examination. And the purpose of that would be to bring out evidence that helps your side of the case. You understand that?
yes,
Now, in the Constitution, Captain, you have the right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. So if you have witnesses that you want to testify for you, that you're not certain will come in voluntarily, then at your request, the court orders them to appear through what's called a subpoena, which is a court order. And then that would make them come to court to be available to testify on your behalf if you wanted them to, even though they didn't want to be here or be involved. And that's the same way that the state's witnesses against you are forced to come into court and testify. Do you understand that?
yes,
All right, now, under the Constitution, Ms. Captain, you have a privilege against self-incrimination. And what that means is that you cannot be forced to give evidence in this matter at any time, including trial. So no one can ever make you testify. The prosecutor can't, the judge can. You make the decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way, at any time, by anyone in the proceeding. In fact, it's not even allowed to be mentioned during the proceeding, except in one situation. If there's a jury trial and you decide not to testify, the judge instructs that jury that they cannot consider it for any purpose because that's your constitutional right. Do you understand that?
yes,
All right, now, Ms. Captain, under the Constitution, you're presumed innocent of this charge until proven guilty by the state of Ohio of every essential element of the offense charge of proof beyond reasonable doubt. But what that means is that the witnesses against you have to come into court and testify in front of you. I'm sorry, what that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any evidence in your own defense at all. You may, but you're not required to. But whether you present any evidence or not, the burden of proof remains upon the state of Ohio to prove your guilt, or proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
yes,
Now, originally you entered a plea not guilty, Ms. Captain. That plea denied the allegation in the indictment, denied you committed any crime, and that plea exercised all of the rights that I've just described for you today. Now, if you change your plea from guilty or from not guilty to guilty, that is the complete opposite. The plea of guilty admits the allegations in the indictment, admits that they're a crime, and that you committed a crime. And that plea waives, gives up all of the rights that I have just described for you today, except your right to have a hearing. You always have a right to have a hearing no matter what you plead. You always have a right to have an attorney no matter what you plead. So you don't waive your right to counsel. But with that exception, your plea of guilty would waive or give up your right to have a jury or a court trial. It would waive or give up your right to confront witnesses against you and cross-examine them through your attorney. It would waive or give up the right to use the power of the court to compel or force witnesses to come to court to testify for you, the same as the state. It would waive or give up your privilege against self-incrimination because you're the one saying you're guilty and that's what you find you guilty. It would waive or give up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. Now, that plea also subjects you to being sentenced immediately by the court. Finally, it gives up any right to file an appeal that you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence or under other limited circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. You understand all of that?
Yes.
They didn't call out to the jail, they signed off. I had a plan, and then they signed off.
Judge, your sound went out.
I know, I muted myself, I was talking to Bill about another
Okay,
case.
sorry.
Yeah, the jail was on and they signed off and I was telling him to get over there. Okay. Now, you are a U.S. citizen?
Yes.
All right, now do you have any questions? Here they come. Do you have any questions about the charge or the possible penalty?
No.
You understand it?
Yes.
Do you have any questions about the plea agreement?
No.
You understand it?
Yes.
Do you have any questions about the constitutional rights I've explained to you?
No.
Do you understand those?
Yes.
Do you have any questions about the plea of guilty, what it means, and what the consequences of that will be if you enter in here today?
No.
You understand?
Yes.
Now, at this point, is there anything you need to talk to your attorney about, to ask him any questions before we go any further?
I don't think so.
All right, do you have any questions about anything I've explained to you here today?
No.
Okay. Then is it your decision, Mr. Captain, to withdraw your not guilty plea and plead guilty to the charge pursuant to the terms of this written plea agreement that you signed that I just went over with you?
Yes.
Then as to the charge which alleges that on or about the period of September 15, 2021, continuing through October 19, 2021, in Highland County, Ohio, you did, knowing an official proceeding or investigation was in progress, or is about to be or likely to be instituted, did alter, destroy, conceal, or remove a record or document or thing with the purpose to impair its value or availability as evidence in such proceeding or investigation in violation of section 2921.12A1 of the Ohio Revised Code, third-degree felony of tampering with evidence, carrying possible prison term between 9 and 36 months in the increments provided by law, a fine of up to $10,000. How do you plead?
I plead guilty.
You can call the jail again, we lost them. I don't know what they're doing out there, but they keep coming along. Or their system's down, I don't know. All right. The court finds that on this date, open court, defendant was advised of all his per constitutional rights, made a knowing, intelligent, voluntary waiver of those rights pursuant to Criminal Rule 11. Pleas accepted for file. Defendant is found guilty of the charge of tampering with evidence is charged with count 1. Court orders a pre-sentence investigation to be conducted. Bond is continued, and the sentencing hearing will be set for March 2nd at 9 a.m. And that will be an in-person hearing. Unless something happens between now and then, but I hope is that by the last week of February, we'll be able to have more in-person hearings. All right, is there anything further from counsel?
There.
All right, Mr. Argini, you want her to contact the office to get her appointment scheduled for her pre-sentence investigation?
Yeah, we talked today, she's gonna come in tomorrow.
Okay, great.
So,
All right, Ms. Smith, then just get, or Mrs. Captain, get in touch with the probation department, and we'll see you here at court on March the 2nd at 9 a.m. Thank you.
Okay.
All right, you can sign out whenever you want to. Mr. Wagner, I've had the jail on twice, lost him twice, so I don't know what's going on.
We can give it a shot, Judge. I'm like you, I gotta drive to Jackson County for a ball game, so I gotta leave early as well, so. We gotta just reset it, I can be available, Judge.
Okay, well, I'm not in any hurry, I can do it, so, it's just, I'm having Dan call him again. Yeah, I let him in, and, screen just came on and said they were connecting the audio, and then it went out. Well, I don't know what's going on, whether they're having technical issues, or if it's, staff, the new staff unfamiliarity with it. I know Tenor Brown's out, and they've had a couple of people left. They must be shorthanded because I saw the sheriff on there leaving the room, so he was apparently walking down. The bailiff's calling in, I'm gonna go, we're still on record here, I gotta turn this off. I just stopped the recording, I'm not sure how to take us off of YouTube.
New help.
Huh?
New help. They logged in and you were having another case. They didn't think they were supposed to hear that, so they.
Public record. Yeah. Are we still on YouTube?
Let me look.
That's what I thought, it looked like somebody I'd never seen before.
Yeah,
He apparently didn't realize we have,
we're still audio and video YouTube.
that's all right.
Okay.
The hearing's a public record, so they thought they were supposed to sign off on
Yeah.
what we were ready for.
Yeah, they were afraid that they were going to hear something they shouldn't.
Yeah.
Man, that wireless mic eats batteries.
Yeah, it does. It doesn't last long.
You know, if they would just get us another one like this, it'd be fine. We could take it, plug it in, bring it out here. And,
Do we have another plug, or does the system have?
well, see, we've got this one over here, which I covered that up because they could hear prosecution counsel talking to each other in a hearing. If I unplug it, then we get an error message comes up that says mic's not working.
Really?
So I don't know if they could take that out of there, and if there's a place to plug it in under your bench or
Well,
one of these others would be
yeah,
fine.
we could do that, and then, you know, but we need to have that there when we're having a jury trial, or any kind of trial, so that it picks up all the sound.
Well, it would be helpful if we had like two of these, two more, one for up there by yours and one for the.
Are those, the ones on the council table, are they wireless?
Yes.
We should just get another wireless.
We get two more, one for there and then one for the lectern during voir dire.
Good idea.
So,
Might have been, yeah, might have been.
okay, ready to go?
Yep.
All right.
Okay, we're back on record, case number 22CR002 and 21CR186, State of Ohio versus Ralph S. Morrison. The case was called at 1 o'clock, and Mr. Morrison indicated he needed to have a session with his attorney in person, and so Mr. Wagner, did you go out to the jail and see it, come back?
I did, sir.
All right. All right, so, Mr. Morrison, after talking with your attorney, are you prepared to go forward then today?
Yes, sir, Your Honor, I am.
All right. Now, Mr. Wagner, you and your client are both agreeing that this hearing can be conducted remotely using the Zoom technology rather than in-person hearing.
We are, sir.
And you're in agreement with that, Mr. Morrison?
Yes.
All right, thank you. Now, in the event that you have any other questions that you would like to ask your attorney during this proceeding, or if anything comes up that you want to talk to him about, you just tell me. I can put him into a breakout room where it'll be just the two of you talking on the screen and no one else will be able to see or hear you, okay?
Yes, sir. Thank you.
All right, now you are charged in case number 21CR186 with failure to comply, the order signal a police officer and receiving stolen property. I believe that's set for trial February the 7th. Then in case number 22CR002, charged as domestic violence, a 4th-degree felony, and I think that might be set maybe the 10th of February. Let's see here. I don't think it's set the same day. It may be. Let me look here. Actually, it's set for trial on March 21st. Okay. Now, Mr. Morrison, I have been presented with a plea of guilty forms in each case. And these are 3-page documents that the prosecutor's office prepared from the forms they have in their computer. And in case number 22CR002 says you're going to plead guilty to domestic violence. And in case number 21CR186, you're going to plead guilty to count 2, receiving stolen property. I'll hold each of these documents up to make sure you recognize what I'm looking at here. So you recognize that? That's the case 186, plea of receiving stolen property. You recognize that?
Yes, sir, Your Honor, I do.
And then I'm going to go to page 3, and about a third of the way down on the the third page, there's a sentence that says, "I enter this plea voluntarily," and right below that, there's a line and has signature defendant, and you have a very beautiful scroll there, but I can't read it. Is that your
That's
signature?
my doctor's signature. That's my doctor's signature. Don't try to
Yep.
copy it, sir. That's mine.
I couldn't copy it if I wanted to. So,
That's mine, sir.
okay. And then on page, case number 22 CR 002, the domestic violence charge, you recognize that document, page 1 as being the plea form that you looked at.
Yes, sir.
And then on page 3, there's a signature line on that one, and also the same statement, "I enter this plea voluntarily." Is that your signature there?
Yes, sir.
All right, thank you. When did you sign these documents, Mr. Marson?
Believe yesterday sometime, sir.
All right. And I know your attorney was there, went over them with you before you signed them,
Yes, sir, he did.
and then he came out to see you here a little while ago and again talk about everything, including these agreements.
Yes, sir, he did.
And you feel that you've had enough time to fully consider this matter before making this decision,
Yes, sir, I have, sir, Your Honor.
and you realize that by signing these agreements, you're saying that you're going to plead guilty, which means there's not going to be a trial. The next step would be a sentencing hearing.
Yes, sir.
And now, are you entering in the agreement to plead guilty in each of these two cases voluntarily, Mr. Marson?
Yes, sir, I am, Your Honor.
All right, now, the agreement in case number 21 CR 186 says that you're going to plead guilty to the charge of receiving stolen property, count 2, under 2913.51 of the Revised Code, and 4-3 felony. Further states that you understand that the possible penalty for that could be 18 months in prison, the minimum of the prison term imposed is 6 months. It could be a fine of up to $5,000. And then on the case on 22 CR 002, you're pleading guilty to the single count in the indictment of domestic violence under 2919.25A, which is also a 4-3 felony, so it has the same possible penalty as the other charge, 6 to 18 months in prison and a possible fine of $5,000. Now, you understand that?
Yes, sir, Your Honor, I do.
Now, under the law, Mr. Marson, if you plead guilty to each of these offenses, it's possible that the court would order your sentence, if I sentence you to prison, to be served consecutively, meaning one after the other. So that means that the maximum possible penalty for these two charges could be 36 months in prison and a fine of $10,000 total. You understand that?
Yes, sir, Your Honor.
And are you facing any felony charges in any other jurisdiction?
No, sir, I'm not, Your Honor. I've been in trouble for almost 15 years, sir.
Okay. So you're not on probation, community control, parole, or post-release control?
I think I was on probation at one time, but I really can't remember. And no, I haven't been on post-release control for many, many years.
Okay, I mean as of now, not ever, but as of today, you're not.
No, sir.
Right, okay. All right. Now, under the law, Mr. Marson, if you are convicted of these two offenses and serve a prison term, then once you complete that prison term, it is possible that the adult parole authority may, as part of their decision-making process, choose to put you under post-release control supervision. It's what we call optional. It means it's up to them. They don't have to. They'll make that decision. The court doesn't have any involvement with that. Now, if they do that, you'll be supervised on the terms they set, and that could be for a period of up to 2 years, because the law has changed on the period. So it could be up to 2 years, and if they determine that you failed to comply with those conditions, then they could return you to prison for an additional period of up to 9 months for any single violation, but there is a cap or limit of half of whatever prison term was imposed for all violations. Now, if you commit a new felony while under post-release control supervision, then the law provides that in addition to whatever sentence a judge in that new felony case would impose upon you, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of 1 year or whatever time is left on that period of post-release control, whichever is greater or more. And if that happens, that sentence will be served consecutively to the sentence for the new felony. Do you understand that?
Yes, sir, I have been on it before, sir, and I do understand it all.
All right. Now, under the law, these are not mandatory imprisonment cases. So the court does have the power to put someone who's convicted of these offenses under what's called, community control. That's what those people refer to as probation, and it means that you, instead of being sent to prison, will be supervised under terms set by the court, by a probation officer, for a period of up to 5 years. And if during that period of time, probation department felt you were not compliant, they would file a written notice of that with the court. You would be served a copy. You would be entitled to have a hearing and be represented by an attorney. And if the outcome of that hearing was that you had failed to comply, then at that time, the court could revoke your community control and then sentence you to prison to 18 months on each charge, consecutive for a total of 36 months, and fine you a total of $10,000. Do you understand that?
Yes, sir, Your Honor, I do.
All right, now, the charge in case number 21 CR 186 at count 2 alleges that on or about August 30, 2021 in Hinding County, Ohio, you did knowingly receive, retain, or dispose of certain property, being a motor vehicle, as defined under ORC section 4501.01, the property of another William Ramsey, and that you knew or had reasonable cause to believe said property had been obtained through the commission of a theft offense, violation of section 2913.51 of the Ohio Revised Code. So that's a charge received stolen property, 4th-degree felony. In case number 22 CR 002, it alleges that on or about July 31, 2021 in Hinding County, Ohio, you did knowingly cause or attempt to cause physical harm to Lisa Florence, a family or household member, and that you have previously been convicted of domestic violence in Morrow County Common Pleas Court, case number 08 CR 0056 on May 5, 2008, in violation of section 29, and there's a typo in there. It's actually 2919.25. It says 2920.25. So that's a typo. I'll correct that here on the court's own motion to conform to the allegation. And that is also 4th-degree felony, the same possible penalties as the other charge. So each of them have 18 months imprisonment possible and a fine of $5,000. Now, Mr. Marson, do you understand what it is you've been charged with in each of those cases, what the state said you did, when, where, and how they alleged you did it?
Yes, sir, I am.
You understand the possible penalties for each offense and convicted?
Yes, sir, I do.
Now, have you discussed each of these charges with your attorney, as well as the evidence, the possible legal issues, the possible defenses you try to raise at a trial, and the possible outcomes of a trial with your attorney?
Yes, sir, I have.
And are you satisfied with his advice and confidence in this matter?
Yes, sir, I am.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir, I've been in here for 6 months.
Okay. Are you taking any prescription drugs?
As far as mental health medication, yes.
Are any of those drugs interfere with your ability to understand what's going on or to communicate your thoughts effectively?
No, sir, but actually, even if I wasn't on the medication, due to the fact that I have been court ordered to be mentally incompetent back from 1970, sir. But that the medication has no effect on my judgment as far as I have neurosis, sir. You know what that is, so.
Yeah.
This all, yes, sir, go ahead, sir.
No, I understand. Okay. So anyway, you're okay. That sounds like to me.
Yes, sir, yes.
Okay.
Yes, sir.
All right. Thank you.
You're welcome.
Now, on page 2 of each document, the plea has the specific terms of the agreement. And in case number 21 CR 186, there's 4 sentences that are printed in bold. Now I see there's been a change as an ink to a case number on the 3rd line. And I'll read it as follows. Defendant shall enter plea of guilty to count 2. State will dismiss count 1. State defense jointly recommend 12 months incarceration be served consecutively to the sentence imposed in 22 CR 002. Defendant agrees to make restitution of 10 moots in the amount of $250 and Cheney Muffler Center in the amount of $250. Now on 22 CR 002, there's about a little over 2 sentences that are printed in bold underlined on page 2. They read as follows. Defendant will enter a plea of guilty to the indictment. State defense jointly recommend 12 months incarceration consecutive to the sentence imposed in case number 21 CR 186. Now, is that your understanding of the agreement in each case?
Yes, sir, it is.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
Now, under the law, Mr. Morrison, the matter of the sentence is up to the judge. So even though the parties, you and the state, are both in agreement as to what the sentence should be, which is 12 months consecutive for a total of 24 months without any fine, if you plead guilty, I don't have to follow that recommendation. I could give you any sentence between 6 and 24 months that I think is appropriate, and I could also impose a fine if I thought that was appropriate. Do you understand that?
Yes, sir, Your Honor, but due to the fact of the vehicle, sir, I would like to possibly sooner or later sometime pay restitution for that, sir. I'm not going to speak any more on about it, but if it's possible, if you would like to put that as an impose on when I get out, sir, I'm more than welcome to work something out for that, sir.
All right. Now, Mr. Morrison, do you hold any kind of a license or certificate from any state agency for any kind of an occupation profession, like any kind of a professional license, like a nursing assistant or a barber or veterinarian technician or anything like that?
Well, sir, here we go. I'm not trying to brag, too many years, too many years, but if you gave me a certificate for having 14 numbers now, with almost 30 years in the service, yes, I believe I hold the certificate, sir.
But you don't have anything other than that?
No, sir,
Okay.
I don't, no, sir.
All right, well, we don't give out awards for that, so.
No, I know.
Okay.
No,
All right.
Anyway,
Yeah, thank you.
you're welcome, sir.
All right, now you have certain rights you have to understand before you can I can accept your guilty plea, Mr. Morrison. First of all, you have a right to counsel. Mr. Wagner was appointed to represent you. Now, attorneys aren't appointed by the court simply to try to work the case out, but to provide any defense that could be available to you under the law that you would like them to present and try to defend you with. So if you decide you don't want to plead guilty to either of these charges, he'll continue to represent you, defend you, including a trial on either or both charges, if that's what you want. You understand that?
Yes, sir, I do, Your Honor.
Right now, all the rights I'm going to explain to you apply to both cases, whether I say it or not. I try to say it. In case I don't, everything I'm telling you applies in both cases. First of all, you have a right to have a jury trial in each case, in which 12 people would be selected from a group of citizens that live in this county that would be summoned for jury duty on the trial date for that case. After 12 of those folks are selected and seated as jurors, then the evidence will be presented to them, and then the judge will instruct the jury on the law. Then the jury in each case would have to decide by unanimous verdict, meaning all 12 of them have to agree, as to whether or not the state proved your guilt in that particular case by proof beyond reasonable doubt. And that, again, would have to be unanimous, meaning all 12 of the jurors would have to agree on each verdict in each case. Now, if you didn't want to have a jury trial in either of these cases, or both, then you could waive in writing, which means give up, your right to have a jury trial in that particular case. And then, as to that case, a court trial will be conducted. A court trial is where the judge is the one that hears the evidence instead of the jury. The judge applies the law, and the judge makes a decision instead of the jury as to whether or not the state proved your guilt in either or both cases. Do you understand that?
Yes, sir, Your Honor.
Now, Mr. Morrison, under the Constitution, you have a right to confront witnesses against you and to cross-examine through your attorney in each case. So what that means is that in each of the cases, the witnesses against you have to come into the courtroom and testify in front of you and your attorney in a public trial in front of anyone that might be present or watching. Now, once the prosecutor's done asking questions of those witnesses, your attorney can ask questions. That's called cross-examination. And the purpose of that is to try to bring out evidence that would help your side of the case. You understand that?
Yes, sir, Your Honor.
Right now, under the Constitution, you have the right to use the power of the court in each case to compel or force witnesses to come into court to testify for you, just like the state of Ohio. So, if you have witnesses you're not certain are going to come in either of both cases, then you can request the court to issue a court order called subpoena in that particular case or cases, and then those witnesses would have to come to court and be available to testify for you in those cases or cases, even though they didn't want to be here. And that process is the same way that the witnesses against you would be forced to come in and testify in each case in court of state. Do you understand that?
Yes, sir, Your Honor, I do.
Right now, under the Constitution, Mr. Morrison, you have a privilege against self-incrimination in each of these cases. What that means is that you cannot be forced to give evidence against yourself at any time, including trial, in each case. No one can ever make you testify. The prosecutor can't, the judge can't. It's up to you. And if you decide you're not going to testify in either or both cases, then that fact cannot be used against you in any way, at any time, by any person in the proceedings. And in fact, no one's even allowed to talk about that except in one situation, and that is if you have a jury trial in either or both cases, and you do not testify in that particular case, then the judge will instruct the jury in that case or in both cases if that's what happens. They cannot consider it for any purpose because it's your constitutional right. You understand that?
Yes, sir, Your Honor.
Now, in each of these cases, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense in each case by proof beyond reasonable doubt. What that means, Mr. Morrison, is that you're not required to try to come into court and prove you're not guilty simply because you've been indicted. In fact, under the law, you're not required to present any evidence in your defense at either trial. You can, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio in each of these cases to prove your guilt by proof beyond reasonable doubt of the charge in that particular case on every essential element of the offense charged, and that's the highest burden of proof that's known under the law. Do you understand that?
Yes, sir, Your Honor, I do.
All right, now, Mr. Morrison, you originally pled not guilty to these charges. Not guilty plea denies the allegation in each case, denies you committed any crime, and that plea exercises all of the rights that I've just described for you. Now, if you change your plea from not guilty to guilty, that is the complete opposite of not guilty plea. The guilty plea admits allegations in each count of the indictment to which you're pleading in each case, and admits that the facts are alleged are accurate, and that you committed those acts, and that they're a crime, and you committed the crime. That plea, in each case, would waive or give up the rights that I've described for you here this afternoon, except for one, your right to have an attorney. You always have a right to have an attorney no matter what you're pleading. But with that exception, your plea of guilty would waive or give up your right to have a jury or court trial in each case. It would waive or give up your right to confront the witnesses in each case and to cross-examine them through your attorney in open court. It would waive or give up in each case your right to use the power of the court to compel or force witnesses to come into court to testify for you, just like the state. It would waive or give up your privilege against self-incrimination in each of these cases, because if you say you're guilty, that's what's used to find you guilty. It would waive or give up your presumption of innocence in each case, because if you say you're guilty, then that's what's used to find you guilty in each case, and the state will not be required to prove your guilt in either case. It also subjects you to being sentenced immediately by the court, which I think is what is being proposed would most likely happen. And finally, it waives or gives up any right to file an appeal that you think you may have had under the facts of the case up until this point. Now, if I should sentence you to the maximum sentence, or under other certain limited circumstances, you could file an appeal. Any appeal you'd want to file would have to be filed within 30 days of your sentencing entry being filed in that particular case. You understand that?
Yes, sir, Your Honor.
And Mr. Morrison, are you a U.S. citizen?
Yeah, I believe so. I was born in England, sir.
Oh, really? But
My parents were in, I believe, military. Sir, I've never met my mother and father. I know their name on my birth certificate. It's been an ongoing battle throughout the years to try to find out something, but most roads ended up to a dead end, sir.
okay, but you are a citizen of the United States, since your parents were both citizens and you were born overseas. All right.
I can't honestly answer that question because I don't know if they were U.S. citizens. I don't, like I said, I don't know anything about them.
Well, let me ask you this: did you have to get a passport to get back into this country, or did they let you back in without one?
So when I was younger, too young to understand and know when I came back over, it must have been in the 2, 3, or 4, sir. So
Okay.
I can't answer that question on.
So as far as you know, you are a U.S. citizen.
Yes, sir. As far as I
All
know.
right. You've never had to get any visas or anything to remain in the country. You've been treated as a citizen by the government.
Yes, sir. Yes,
Gotcha. All right. Now, you're in the plea of guilty in both of these cases voluntarily?
Yes, sir.
All right. Now, Mr. Morrison, do you have any questions about the charge or the possible penalties in either case?
No, sir.
You understand?
I guess the question, I guess my future is already spoken for, but if I was to just say one thing, this was actually allegedly crime out of passion, sir. My daughter.
Well, wait a minute. You're getting ahead of yourself. You'll get a chance to speak here in a few moments, but do you understand the charges and possible penalties?
Yes, sir, I do.
Okay. Now, do you understand the plea agreement?
No, sir, I do.
Okay. Do you understand the constitutional rights I've explained?
Yes, sir, I do.
Do you understand the plea of guilty, what it means, what will happen if you plead guilty in these two cases?
Yes, sir, I do.
Now, is there anything else you'd like to speak with Mr. Wagner about before we go any further?
No, sir, not at this time. I'm very quite content with what he's done so far, sir.
All right. So, do you have any questions about any of the things that I've gone over with you on this plea agreement, your rights?
No, sir, I was just wondering, is this a question I can ask? I've had all the prison numbers and never been sent to a program.
Okay, well, again, we'll wait, we gotta wait till we get to that point, okay? You're getting as my dad used to say, you're getting a cart ahead of the horse, okay?
Okay, I apologize, yes, sir.
Not a problem, I understand. All right. Then, Mr. Marson, is it your decision to go forward and plead guilty to the charges in these two cases, according to the terms of the plea agreement that we've gone over in each case?
Yes, sir, it is, Your Honor.
All right. Now, as to count 2, in case number 21 CR 186, which alleges an on or about August 30, 2021 in Manning County, Ohio, you did knowingly receive, retain, or dispose of certain property being a motor vehicle as defined in ORC section 4501.01, property of another William Ramsey, and that you knew or had reasonable cause to believe said property had been obtained through the commission of theft offense in violation of section 2913.51 of the Ohio Revised Code. Charge of receiving stolen property that carries a possible prison term between 6 and 18 months and a fine of $5,000. How do you plead?
Guilty, sir.
All right, now as to the charge in 22 CR 002 that alleges that on or about July 31, 2021 in Hyden County, Ohio, you did knowingly cause or attempt to cause physical harm to Lisa Florence, a family or household member. You previously been convicted of domestic violence in Morrow County Common Police Court, case number 08 CR 0056 on May 5, 2008. Violation of section 2919.25A of the Ohio Revised Code, the charge of domestic violence, 4th-degree felony, also carry a possible prison term between 6 and 18 months and a fine of $5,000. How do you plead?
Guilty, Your Honor.
All right, thank you. All right, the court will find that in each case, this date, the defendant entered a knowing, intelligent, voluntary waiver of all rights pursuant to Rule 11 after it had been informed of all of them. Plea in each case is accepted and ordered filed. Defendant is found guilty of count 2 in case number 21 CR 186. Count 1 is dismissed. And in case number 22 CR 002, he is found guilty as charged of domestic violence. Also a 4th-degree felony. All right, now, given the fact that there's not a pre-sentence request, this has been a joint recommendation, and Mr. Marson has been extremely candid and open about his past, so the court is not going to order a pre-sentence investigation, and we'll go ahead and proceed with sentencing forthwith. Now, anything from the state regarding sentencing?
Only what is contained in the plea agreement, Your Honor.
I did neglect to ask Mr. King in each case that we consulted with the victim or victims regarding this disposition.
Yes, Your Honor, both victims have approved of this agreement.
All right, thank you. All right, Mr. Wagner, on behalf of your client.
Now, we would ask the court to file the recommendation to steal some of Ralph's thunder here, because I know it's coming next. From our discussions, Ralph has repeatedly asked about treatment and programs. I indicated the court's always open for anything that an individual can complete in the prison system to better themselves, but with having 13 numbers, the court is highly unlikely to go with community control along with a program. I indicated to Ralph his best path, in my opinion, was once he gets to the prison system, sign up for as many programs as possible. If the DRC enters him into transitional housing or transitional control, the court typically goes along with that. That would be his best avenue for a quicker release, Your Honor. But again, I know that's what he's going to ask you about, but again, we still agree with the recommendation, sir.
All right. Now, Mr. Marson, anything you would like to say?
Sir, I would just like to say exactly what he said, but, I know that that's not gonna probably be a possibility, but there were some good programs out there, like ACM, Another Chance Ministry. They said they helped me get me, my social security started, give me a job, housing, I can become a counselor afterwards. I've never ever had a behavioral modification program. I've never even had a chance to have a program. And as we can see, prison's just not working either. I do have a severe heart condition, called congestive heart failure, AFib, and high blood. 186 over 116 the other day, sir. They say I need a pacemaker or a transplant, but I'm not looking to get in. I was not looking to get into a program to get out of any kind of punishment at all. What I was looking for is a new. I've just now recently read the AA book for the first time in my life. I still can't put it down time after time. That's not been one of my things over my lifelong of drinking. I don't know if it was my father's DNA or what caused me to drink. The loss of some of my children, my grandchildren, my friends. I got my wife on life support right now in Marion Hospital. Her name's Cheryl Smith. They don't know if they're going to pull the plug or my daughter has to do it, sir. So, and I do have a long history of never having parents, loved ones, family, anything. I was always found encouragement in the 1970s. That meant that there was no Adderall, Ritalin, no kind of anything to try to correct the mental health disturbance. So, yes, I am of sound mind, but no, I'm not a sound judge sometimes. I'd like to apologize to both victims wholeheartedly. I would like to apologize in any way possible to make anything good. I speak to the higher power up there, but other than that, Your Honor, I thank you and I accept whatever you give to me, sir. Thank you very much, sir.
All right, thank you. Well, looking at the cases, you do have a pretty lengthy record. The thing about programming is that, there are a lot of programs available out there when you're not in custody. Whether there's programs available in prison, although sometimes depending on the length of the sentence, whatever, it's hard to get into. I understand that. But then there's also, you don't have to be in prison, you don't have to be in front of the court to get help. And, it's unfortunate you haven't apparently done that on your own. It sounds like maybe you're there where you think you should now. The problem, Mr. Marson, is that your record includes a lot of things where you're hurting people, physically and in this case, property, damaging property and causing harm to other people. And I'm looking here at your record, you have a burglary, you had an assault in 2020, where you were to get anger management, it looks like from, I don't know if that's municipal court or county court that was in Hyde County. And you had, prior domestic violence, decent resisting arrest. Actually, it looks like you had a couple of prior domestic violence, one in 1988 in Franklin County as well. So the problem is that the court has to protect the public. The public expects to be protected when, persons that cause harm are convicted. And so, given the fact that, the most serious offense against you that could have carried 36 months, 3 years, was dropped, and there was a joint recommendation. It's a judgment of the court that you be fined in each case to a period of 12 months in the Correctional Reception Center in Warren, Ohio, and those sentences are ordered to be served consecutively. The court finds that that's a joint recommendation, but as well, the offenses are two different courses of conduct created over a similar period of time within just a few weeks of each other. And that one single sentence did not accurately reflect the seriousness of the offense, and the sentences are not disproportionate to the crime, and it is a mid-range sentence as opposed to a maximum sentence. And given the fact that, as a defendant acknowledges he's had a very long criminal history, it's required to protect the public. The court also orders that the defendant pay the court costs with judgment and execution order. And if you don't do that, Mr. Marson, then the clerk can collect that through various means, including letting on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then once you complete your prison term, on while you're in prison, once you get out, and you could be ordered to do the service to be given credit for each hour you work, and then are raised set by the court each hour you work, reduce your judgment by that amount until paid in full. And according to the sheriff, you were arrested originally and held case number 21 CR 186, and so all of your time in jail goes toward that sentence of 149 days. the 0 days of 22 CR002, which were already incarcerated when we were indicted on that charge. You're ordered to pay restitution in case number 21 CR 186 in the amount of $250 to Tim Moose and also $250 to Cheney Muffler Center. And those payments are, you'll have to make those payments through the victim witness office's restitution escrow account, paying a fee that might be charged for that. That's a substantive part of the sentence, Mr. Marson, which means that even if you serve your entire prison term, you're still required to make those payments, and they cannot be discharged in bankruptcy. All right, is there anything further from counsel?
No, Your Honor.
No, Your Honor.
Mr. Wagner?
No, sir.
All right, you'll be remanded in custody, Mr. Marson, be conveyed to the institution. Thank you.
Thank you, Your Honor, thank you, everybody involved.